Hi, everybody. This is Jerry Garrettson, Tabia Law, and we're going to continue our walk through the history of immigration in the United States. I'm going to go ahead and read this first. Let's read. And God made the beast of the earth after his kind, and cattle after their kind, and everything that creepeth upon the earth after his kind. And God saw that it was good. Last week we left off at the May 5th, 1892 Act, all Chinese immigrants excluded from U.S. for 10 years. Chinese illegally in U.S. could be removed. Let's move into, I have a new page of acts here, and we'll go from there. What I want to do is just give a brief overview of all the acts that were introduced in part of our immigration law since the beginning of the country, and then what I'll do is I'll go back and kind of flesh those out a little bit. So and take each one in and give some background and some details on that. So here's our next act. November 3rd, 1893. The Chinese legally in U.S. must apply to directors of internal revenue for certificates of residence or be removed. July 26, 1894, aliens who received honorable discharges from U.S. Navy and Marines are not required to file declarations. June 29, 1906, the Bureau of Immigration and Naturalization established. Naturalization papers become standardized and contain more detail about aliens. Any court having common law jurisdiction could naturalize aliens. March 2nd, 1907, American-born women who married foreign-born men took the citizenship status of their husbands. Once the marital relationships was determined, the women could regain their American citizenship, but no mechanism for regaining citizenship was identified. Right. May 9th, 1918, aliens currently in the U.S. military permitted to file for citizenship after serving 3 years. Of course, this is 1918, is World War I. So this country was looking at building its military and thereby recruiting soldiers and giving incentives like immigration. All right, so May 19th, 1921, Quota Act of 1921 established annual immigrant admissions per country using a formula based on the 1910 federal population census. September 22nd, 1922, allowed alien wives of U.S. citizens to file for citizenship after 1 year of residency, stopped removals of citizenship status from native-born American women who had married aliens not eligible for U.S. citizenship. May 26, 1924, a ceiling placed on number of immigrants in permanent status aliens to obtain visas in advance from U.S. embassies. Courts no longer allowed to determine naturalization eligibility. The law was aimed at further restricting the Southern and Eastern Europeans who were immigrating in large numbers starting in the 1890s, as well as prohibiting the immigration of Middle Easterners, East Asians, and Asian Indians. June 2nd, 1924, American Indians were granted full U.S. citizenship to America's indigenous peoples called Indians. In this act, the 14th Amendment guarantees citizenship to persons born in the U.S., but only if subject to the jurisdiction thereof. This later clause excludes certain indigenous peoples. Sorry about that. May 2nd, 1929. Certificates of arrival showing date and place of arrival and method of arrival to be issued to immigrants. Persons wishing to become citizens required to file certificates of arrival with declaration and intention. If they arrived before the certificates of arrival were required, they must be located on a passenger arrival manifest, and retroactive certificates would be issued. June 25th, 1936, allowed American women who had lost their citizenship because they married aliens to regain citizenship by taking oath of allegiance to the U.S. And finally, June 27th, 1952, established national origins minimum quota of 100 persons. We're going to stop there today, and we'll get the rest next time. All right. Thank you so much. You guys have a good day, and we'll talk to you soon.